Okay, thank you. So Senate Government Operations, it is Thursday, April 8th, and we're going to start with the OPR bill. And what I'll do is we'll introduce ourselves because you're not usually with us, so you probably don't know who we are. We'll introduce ourselves, and then if you want to talk to us about your issue in the OPR bill. And we will be joined by Senator Clarkson, who is currently in the Rules Committee and is just trying to transfer. So I'm Jeanette White. I'm from Windham County.
Hi, I'm Anthony Polina from Washington County.
Brian Collimore from Rutland County.
Aisha Ram from Chittenden County.
So would you like to tell us the issue that you have with the way the pharmacy section of the OPR bill is currently constructed?
Yes, again, thank you for the opportunity today. So my name is Michael Duteau. I am a pharmacist by training. I'm president of the Vermont Association of Chain Drugstores. And I would like to preface my comments with the fact that we have been very engaged with OPR on this conversation. It's been very productive, very professional. We have a great deal of respect for the director. We've had some input, and we are okay with the first section, Section A, that's proposed, but we are still at a place where we agree to disagree on Section B, the part that defines drug outlets and chains. We feel that the practice of pharmacy is just that, the practice of pharmacy, and chains and drug outlets should not have separate regulations. Again, as a pharmacist who's practiced in hospital, independent, and chain settings, it was always upon me and my professional judgment to ensure that I practiced in a safe and professional environment, and the regulations should apply to all pharmacies independently.
And so how would you change it? Just
We feel that Section A, along with other existing regulations, provide the tools necessary to OPR to adequately and accurately enforce what the intent of the law is. We feel that adding in B confuses the matter and, again, separates two types of practice when in reality they're both pharmacies.
okay. Any question for Mike? And I don't see Lauren with us yet. Any questions for?
I'm
Mike?
honestly trying to find in the bill where
I am as well.
I think it is.
There's Lauren.
It is Section 5, I believe. Did you find it?
No, with all due respect, the copy I have is all about mixed martial arts. I can't find anything about pharmacy.
If you look at H289.
As
Good.
passed by the House. There should be two bills posted for H289 today. One of them is the amendment we've been looking at. The other one will say as passed by the House. And that's where Section 5 is.
There's only one up right now, unless let me refresh. There we go. Thank you.
So Lauren, do you want to comment on that? About why we would have separate discipline procedures for chain drug stores?
Sure, I apologize for being a little late.
No, that's fine.
For the record, Lauren Hibbert, Director of the Office of Professional Regulation. The office and the Board of Pharmacy engaged in a survey of pharmacists in the fall after concerns came up with our office on the workplace conditions of pharmacists. We have always had some workplace conditions, some rules about the workplace conditions for pharmacists. For instance, pharmacists are supposed to take a meal break. That has been in our rules for some time. It is a patient safety rule, not a workers' rights rule, but it is a patient safety rule. I think it is important to remember what pharmacists do. Mr. Duteau clearly knows what pharmacists do. He is one, and and takes his role very seriously. And I appreciate, I've had many conversations with him and I know he takes his role seriously. But pharmacists, not only do they count and dispense medication, that's the most simple parts of their job. They're really responsible for drug utilization, counterindications, making sure that the prescription is appropriate for the diagnosis. They do, after the work that this committee did last year, they now are providing vaccinations, birth control. There's lots of things that pharmacists are able to do now. They have a very important clinical role. And the pattern that we saw after our survey was that the expectations put on chain pharmacists, people who work in chain pharmacies, is unreasonable compared to what is placed on people, pharmacists working in other environments. And that corresponded with what we had heard, which is what made us do the survey. So when Ron and I was discussing this section of the bill on the House side, I submitted the results of our survey, and I'll do that today to this committee so that you can see the trends that we saw. People not being able to go to the bathroom, not being able to have a meal break, people pumping, breastfeeding mothers pumping behind the counter because they did not have a place to pump, nor did they have time to pump. So some really serious concerns were brought to our attention. We do take our responsibility seriously to make sure that the workplace is safe for the pharmacist and for the consumer. And in pharmacy, we have a unique responsibility because we regulate both the pharmacy and the people who work within it. So we've always had oversight of the environment, plus the people who work in the environment. I'll say that this bill, it certainly was the unprofessional conduct is not. It's not addressed only to chain pharmacies. Unprofessional conduct would apply in non-chain pharmacies. It doesn't call it out, but the piece that does is if we see a pattern in one, then we can start to apply it to others with notice and due process. So that if we see, I'm going to make up a Harry's drug chain. I'm making up a drug chain just because I don't want to cast aspersions. If we see Harry's drug chain has a problem in Brattleboro, and we provide notice that we think it's a problem in Brattleboro and in White River and in Montpelier and in Burlington, then we can proceed without having to do separate investigations and prosecutions. And this is so that we can start to address systemic problems as opposed to just playing whack-a-mole, which is where we are right now.
So how do you, I guess, define, I'm thinking, for example, of, would this apply also to, I think that the Montpelier pharmacy, which is called something different now, actually owns the Brattleboro pharmacy. I mean, we have a hotel pharmacy, which is completely independent, but we have Montpelier, I think, owns the Brattleboro pharmacy. Would that be considered a chain?
Yes, they're both Kenny's.
Oh, but they were bought out by Kenny, but they weren't originally when Montpelier bought Brattleboro, they weren't part of Kenny. They were just two pharmacies, but owned by the same place. So would they be considered a chain in that case, so that if you saw problems in Montpelier, you could also apply them to Brattleboro?
Yes.
Okay. So it isn't chain in the sense that we think of as the chain pharmacies, but it's if an entity owns more than one pharmacy.
Exactly. So it is if it's more than one location owned by the same corporation, entity, or person.
So the regulations aren't different. It just allows you to, if there's problems in one, it allows you to open an investigation into the other sites owned by that same entity. Where with an individual independent pharmacy, there wouldn't be a need to have this because you're investigating them and there's only one of them.
Right, but we still could use the first half of this
Well, yeah,
section,
yeah.
which
No,
against
I
them. But this second half of the section, we would use if we saw evidence of a corporate policy that is a directive not from the pharmacy manager in a particular pharmacy location, but is something from a higher entity. And it goes into the systemic problem of how we regulate pharmacies. We don't regulate CVS or Kenny or Walgreens. We regulate CVS 1950 located in Berlin. I don't know if that's the number of the CVS in Berlin, but that's how we regulate. We don't regulate CVS. We regulate the location of the retail outlet. We regulate the building itself.
Okay, got it. Senator Collmore?
Thank you, Madam Chair. And Lauren, forgive me if I'm misinterpreting this, but it seems to me that you're painting the chain with a pretty wide brush. Why? There's almost a presupposition that if there's a problem in Rutland and it's owned by the same company, that there would be a corresponding problem in Brattleboro. I guess I don't understand why you still would just not go to the problem. And if it's only one store, even though it's owned by a chain, you deal with it just like you would deal with an independent pharmacy. Maybe I'm missing something.
No, Senator Collmore, if we found that there was a problem and it was exclusive to one chain, then we would pursue action as we would an independent. We wouldn't automatically jump to the remainder of the stores. What the times that we would go to the remainder of the stores is if we found in the course of our investigation or inspection a corporate policy that is making those individual outlets act in a certain manner. So there are all sorts of policies that that our inspections unit have bumped into, or that pharmacists have told us, yeah, I wish I could do that differently, but that's the corporate policy. And we're finding themes throughout the state of institutions that pharmacy manager in one and pharmacy manager in location 2 and pharmacy manager in location 3 say, yeah, this is corporate policy, so I can't not do this. And so right now our option is to pursue action against each individual pharmacy. And some of our pharmacy outlets have multiple locations. So then we're looking at 15 actions, 15 investigations, 15 inspections. And we see that the problem is not the particular location, but is a policy that's coming from a location that we do not regulate. And so this is a way to put the consumer on notice that this is a theme, a problem. It's a way to, it quite frankly has gotten quite a bit of attention from corporate pharmacy. So it's a way to get the corporate pharmacies' attention that they need to change their policies and pay attention to what Vermont rules are. So it's a way to give the regulator some more power to affect change faster.
Okay, I'm still not 100% comfortable with it. Maybe I could ask Mike to respond.
Yeah, please.
Again, thank you. We've had some, what I consider to be really respectful dialogue around this, and we still do agree to disagree. You know, from our perspective, we went through the survey. Community pharmacy is predominantly the main practice in Vermont, with chains being much more numerous than independents. Hence, we, of course, were the majority of the respondents. But in looking at some of the complaints, there are things that we need to continue to do better, not as a chain, not as an independent, but as a profession. And a lot of the issues are not the direct result of a corporate policy, but there are some things that better policies and better practices could do to help solve those issues. I apologize, I'm on a green light switch. But in any event, you know, from our perspective, we feel that should be able to suffice, and there are other mechanisms that would be able to achieve what OPR is looking to do without sanctioning all of the outlets. With that being said, I want to make sure, you know, that I accurately convey that we are very respectful of the intent here, and we very much would engage after one finding to ensure that we are headed in the right direction, if that's the best way to say it. I mean, I think, again, everybody here is on the same page. At the end of the day, it's about improving safety and access for the patients, and that's what we both want. Both of our groups want that to occur. I think we just have a divide in the middle as to how to best achieve that.
So I just have a question for you, Mike, I guess, about if it is a corporate policy that is determining the actions of the pharmacy in Berlin, it also is determining the actions of in Brattleboro and in Ludlow. So why would we ask for those same issues exist in each of those places if it is a corporate policy? Why would we have to put OPR through doing in this case, three investigations instead of just one?
And again, that is a great question, and that certainly is not our intent. Where we feel that there perhaps is a disconnect or a divide is we're not aware of any pharmacy that has a policy saying you can't take a lunch break or you can't use the bathroom. But there are interpretations by pharmacists who are required to use professional judgment to make decisions. There are different interpretations of policies from one store to another. And I think that's where we're most concerned is, a pharmacist may decide this is what it means for my pharmacy and how I practice, and another pharmacist may read that differently. That's incumbent on us as operators to ensure we're having conference calls, we're properly communicating with our teams to ensure that we are consistent in how we practice in all of our sites. But again, one policy may not be interpreted the same way by pharmacists across the same chain. That's difficult for us to envision as a regulation that is just applied back to us in a flat or a broad brush capacity. But I do think it's incumbent for us to be able to engage in conversation. Once OPR brings us to our attention, there's due diligence on our side to make sure that this is not something that's occurring in all of our outlets.
Lauren?
I respect what Mr. Duteau is saying. We have tried his approach, which is to talk to corporate about the issues that we've seen, and we have not seen substantial shifts in some of the problems that we're seeing. So I can't speak to his particular, where his employer or his, group, but we have had this problem repeatedly. We have tried to address it in every way that we can. Our inspectors correspond with corporate pharmacy executives all the time to try and resolve whether this is the policy or not. And it's been a challenge. And so that's why we sent out the workplace survey. That's why we're here with this proposed solution. I do think there's due process here. There's notice here. There's the ability for the corporate entity to come in and represent its group of retail outlets and explain how this is an independent pharmacist's decision and not the pharmacy's policy. And it would have to have due process attached to it. So that's an important piece, something that, I think this approach is unique. I don't think this has been tried in another state, as far as I can tell, this type of approach. But I think it might be the most successful to address the problems that we're seeing.
Other questions, committee, or comments? I mean, I guess we're not holding the chain drugstores to a different standard.
No.
What we're doing is saying that if there is something that seems to be a corporate policy, that it's going to affect all of them. And so when you come across that, what do you initially do, and where does the ability then for the corporate to come in and say, well, this is our policy, this is to be interpreted by the pharmacist? what actual action do you take once? Can you explain that a little bit, Lauren?
All right, be happy to. So some of these issues will come up for us on an inspection. All of our pharmacies in the state, whether they're chain, independent, hospital, compounding, are inspected once every 2 years. So some of these issues will come up in that inspection process. There is always a fair amount of document gathering and fact gathering in the inspection process. They would be referred if there was a significant problem. The first approach of our investigators is to educate and remediate. Sometimes that cannot occur in the inspection process, and a case is referred to our enforcement division. That's the first way that we get cases into the enforcement division from pharmacies. The second is consumer complaints, and we've had a large uptick of consumer complaints about pharmacies in the last couple of years. So in either case, once the complaint walks in the door, whether it comes from a consumer or whether it comes from our inspection division, we will investigate it. We have an investigators assigned. They then go out on a fact-finding mission, talk to the pharmacists, gather documents. If needed, they would talk to the corporate entity. And then if a pharmacist would be assigned to that case as a board member, as an I-team member, a prosecutor would be assigned to that case. The prosecutor would make his or her independent discretionary decision on whether or not to prosecute the case after hearing the advice of the board member. And then that case would be charged in a charging document that would have to outline what the concern was, how it violated the law, and what remedy they were seeking. And then that is a public document that would be shared obviously with the parties, which would be the pharmacy. And the pharmacy is part of the corporate entity. So the corporate entity would have notice. And then it would be scheduled for hearing, but before the hearing, there's a full discovery process, which can include depositions and exchanging of exhibits. There's quite a bit of time to do some fact finding before there's a hearing. It is not a slow process, and it's not a process where people can't be heard.
So the process, but there's a lot that happens before there's public knowledge about. I mean, you're investigating, you're talking to the pharmacist, you're talking to consumers, you're talking to the corporate headquarters, all of that, trying to figure out exactly what is going on before you decide whether there's actually a case there to prosecute.
Yes.
So,
and
go ahead.
I was just going to say that we don't prosecute a fair number of cases. We decline to prosecute a fair number of cases because we think the investigatory process in and of itself served its purpose.
So I guess I don't understand what the issue is then if all of this is done before there's, I mean, I wouldn't know if the two Walgreens in Brattleboro are being investigated or not before there's actually a case, before there's a decision to assign a case to it and to prosecute and charge. So many things can be worked out before I, as a customer, if I am a customer, am even aware. So I guess I don't understand the issue then, because you would find out in that investigating, in that pre-charging, you would find out whether there was, if the corporate headquarters said, nope, that's something that they can interpret, it's up to them to figure out how to do it, or the pharmacists, all 5 of them say, nope, we can't interpret that. We've been told this is the way it is. But you'd find that out before you ever got to a charging place, right?
Yes, we would find that out, or at least we would come to a determination on our own of whether we thought that had happened. But then even after we charged it, there's the opportunity for the retail chain to come in and say, your assumption is incorrect. Your understanding of what's happening is incorrect, and here's why.
Okay.
so they can come in and rebut what we have found.
Okay, yeah, that's a little, when I was thinking about this originally, and I spoke with Heather about it, I was thinking that it was different standard that was being applied. But
it's a different disciplinary standard, I would say. That's where I think it's different. I want to be respectful to Heather's understanding, because what's happening is, instead of doing an independent investigation, let me say this, if we have a problem with a mental health counselor, we investigate that mental health counselor, and we don't assume that another mental health counselor has the same problem, just because they're both mental health counselors. But the difference between a mental health counselor and a pharmacy is that there's someone in here, up between the two of them, that's telling the pharmacy A and pharmacy B what they need to do, how they need to, the technology they need to use, the notification to patients they need to use, the number of prescriptions they need to dispense, the number of vaccinations we're trying to get done in a day. That's not done at the pharmacy A's decision making. That's done by the corporate entity.
Brian, I think you had, Senator Polina?
I did.
Senator,
How many chain pharmacies operate in Vermont? Do you know?
I do know, but I don't know off the top of my head.
Okay.
Let me take a look at something and I'll get back to you. I do know that.
And then the second question that I have, out of those, have you ever found a situation where every single last one of them is doing the same thing based on a corporate decision?
Yes.
Okay.
We know of problems that come from a corporate decision that are radiating through every chain that is that corporate decision maker.
And you've attempted at some level, Lauren, to contact corporate headquarters and say, hey, look, we got a problem here. What can you do about it? And you're saying that they're either ignoring you or you can't resolve it? Huh. Okay.
I do know that there were tons of complaints from Bennington and Windham counties. I believe it was, I don't remember which chain it was, but I know that there were a lot of, and the poor people who were working in the stores were, I mean, they were caught in between, because I do know that because we experienced it down here, and I know in Bennington, Senator Sears has talked to me about that they experienced it a lot. So Senator Collum, Polina, you had a question, I think, and then Senator Clarkson.
Yeah, I think I do. I understand from Lauren's point of view why it makes sense to do it this way. But I'm not really sure what the downside is to the pharmacy, to the chain pharmacies, to tell you the truth. Partly is you don't want to be painted with a broad brush. Is it just sort of a pain in the butt because you have to deal with all these things? I just want to really kind of what the bottom line is. Why is it a bad idea? Mike, I guess.
Sure. So I can provide some insight, and I will disclose, Lauren's aware of this. I'm licensed to practice both in Vermont and New York. I spent 15 years on the New York State Board of Pharmacy, and we managed 5,000 individual locations without this type of policy. I will say, and I mean this as a sincere compliment, I think the communication with Vermont OPR is at a much higher level, and obviously there's an opportunity for us to engage at the same level. One of the concerns that we have is a black and white piece of paper or an email with a policy. That's understandable. And again, I don't think that's what we're talking about. We're talking about interpretations of corporate communications. A good example is Lauren brought up how many vaccinations or how many prescriptions you fill. My company doesn't have a policy around that, right? The business comes in, but we do know how many prescriptions you fill, whether or not you have a drive-through. If you're doing immunizations, that does play into how much payroll we can give the store manager to work with. And that's the concern, is that amount of payroll may work very well for a pharmacist in 20 of our locations. but we may have a pharmacist in one of our locations that perhaps practices differently or can't keep up, and despite adjustments or interventions, they can't make that work, or they're having a hard time. If an error occurred and OPR went in and they said, well, it's because of a corporate policy, that's why I made the error, we would have a hard time with that then being applied to all of our other sites. And again, that's probably the exception, not the rule, but that is why we are raising our hand and saying we don't think it's as simple as just 3 bullet points in a policy. But in all fairness, there is a lot of discussion that occurs in the process. OPR is very good at outreach from my personal experience, very reasonable in having discussions. And again, we've had a lot of productive dialogue about this to this point currently. But that's an example of something I feel could be pulled into this and applied as a corporate policy when in reality, it's really at the practitioner level.
Lauren, I thought you wanted to say something, but before you do, I just want to, I think there's a part of the bill that says that discipline will only be enacted if the conduct was found to be at more than one location, more than one outlet. So it seems like you have to find that there's at least a bit of a pattern before you take action, disciplinary action. But I'm sorry, you were going to respond.
No, Senator Polina, you're making the point that I was going to say, which is there does need to be a pattern, and Mr. Duteau's company could come in and say, this is a problem unique to this location with this particular pharmacist. We don't have the problem in other places. And that the corporation could do that at multiple points in the inspection, in the investigation, and certainly at the hearing. So there's multiple opportunities to make the point that he would be entitled and appropriate to make, which is, this is not a problem that's universal or because of the corporate policy. This is because we have an employee who can't meet our expectation for a whole variety of reasons, and we're trying to remediate that.
And you could do that at the moment you found out there was a problem in one location. There would be the chance for corporate to say, that's a problem of that location. It's not a policy of ours.
Yes, and that conversation is happening now with investigations and inspections. So we have those conversations with the corporate entity, and they do explain that it's not corporate policy. It was a particular pharmacist's mistake or error, and then we don't pursue action against the pharmacy itself. We pursue it against the particular pharmacist. So that type of investigation, that type of trying to filter out who is responsible for the conduct that may have harmed a consumer or could harm a consumer if allowed to continue, we're doing that analysis now. What this changes is if we find that it's because after our investigation or after our inspection and investigation, if we find that it's because it's a corporate policy, and we find that it's happening in multiple locations, then we don't have to open up a case and investigate a case in every location in the state. We would notice every location. Every location would have due process rights and would be able to come in through the corporate entity. And we would have that discussion on a much higher level than we're able to have it now, in a more formal way than we're able to have it now.
Okay. Sarah Clarkson, I think I saw your hand up.
No, thank you. I'm just, getting up to speed. I'm sorry I was late. I apologize. Where I was in Rules Committee. I actually support this. I think this is good. And as Anthony pointed out, it has to happen in more than one location. There are more, just to answer Brian's question, there are more than probably 5 chain drug stores in Vermont, and then there are all the food stores like Price Chopper or Hannaford's or wherever that also have drug components. So there are probably 8 or 9 different entities that this might apply to, is my guess.
It could also apply to health systems, right? If I understand correctly, if a hospital operates multiple pharmacies.
But we don't have, oh, right.
I guess I'd like to ask one more question, if that's okay.
Sure,
I mean, if I'm part of a chain, let's say you find some kind of unprofessional conduct, and you find it at 2 or 3 stores that are part of a chain of 10. The other 8 or 7 that you didn't find it at because you didn't need to go through all that, they're going to get a notice of enforcement of some sort. Can you just give me an example of how that might work? So I'm a pharmacist down in Brattleboro, and I'm going to get a notice of an enforcement telling me that others in my chain have done something wrong. I mean, I'm just wondering how that's going to be played out. Not a very articulate question, I know, but you get my point.
Okay. I'm struggling with my light today. I apologize. I'm in the dark, but
there seem to be a lot of light challenges today. There's a light that's too smart and is outsmarting the owner, and there's
maybe.
Yeah, it also could be related to the fact that it's actually sunlight coming in these days. You know?
No, it's lovely. It's a lovely problem to have, but
right.
I will try. I'll go off camera and try and remediate it at some point. What will happen is when a pharmacy is registered with the state, the contact information and the corporate agent is attached to it, the person who receives notice if charges are filed against it. So it could be a pharmacy manager for the outlet, or it could be someone within the corporate entity. So that person, whoever is identified, will get notice of the charges, and then will be given notice of how to respond to the charges. And you have to respond within 20 days. Does that answer your question, Senator Polino?
But if I was not one of the 2 or 3 that you actually investigated, I would get this notice in the mail or somehow that says I'm being held responsible for something that I didn't do, that you don't know if I did it or not.
I think the important distinction is it's not a person that we would be saying you did this. It's the location. Okay. So it would not be the pharmacy manager. It would be the location of the pharmacy, the building and the entity of the pharmacy.
Okay.
Because you could take action against an individual pharmacist in a chain or not in a chain without impacting the pharmacists in the other locations in that chain.
Absolutely, and we do. So currently, perhaps not currently, I think in the last couple of months, we had a pharmacist who was diverting narcotics from his pharmacy. This unfortunate, it happens. It clearly wasn't any of the pharmacists who worked with him's fault. It wasn't the chain's fault. It was just his misconduct. So we charged him. We didn't charge the place where he worked. Now, had we found that they had no system to control, count, or manage narcotics that enabled him to divert and made it easier for him to divert, then we might have charged both, right? So that's the analysis that we do when we find unprofessional conduct that's occurring in a facility where we license the facility and the pharmacist.
Senator Kalmar?
I don't mean to prolong this any longer than it needs to be, but what exactly does your notice say, Lauren? And again, with all due respect, it still feels to me like you're making a chain guilty before you've done due diligence. I mean, isn't your job to look at each pharmacy and not to make an assumption that just because it's part of a chain that there's malfeasance going on in all of the branches? In other words, if, to Senator Polina's point, if I operate and again, I'll just make up a name, a Bryan drugstore, but I'm not doing whatever it is that is the problem, but 3 of my other branches are, what is that notice going to say when I get it as an innocent person? Your chain is under investigation, or how does that work?
So looking at the statutory language, and to be fair, we have not had a notice like this to date. So I don't have an example that I could give you. I could give you an example against a specific outlet that's within a chain, but I can't give you an example where I'm trying to do this because it's a new statutory construction. But what would happen is B1 says that the state must provide with in a specification of charges that unprofessional conduct occurred in one or more drug outlets, then that the unprofessional conduct, so that's fact one. Fact two that has to be alleged is that the unprofessional conduct is attributable to pharmacy or pharmacy business related policies, procedures, systems, or practices of the chain, whether or not those practices manifested in unprofessional conduct at each individual location. And the state would have to argue that the imposition of disciplinary sanctions or conditions against all drug outlets in the chain are appropriate to protect the public. And I think it's the third factor that will be the most debated of, yeah, this was our corporate policy, but it's happening at one, it's causing a problem at one, but not all. Or no, that this happened at this location and we have a corporate policy, but what happened wasn't the result of the corporate policy. That's factors 1 and 2, and I think those will be debated. But that third factor of that a condition or a warning or a sanction needs to be imposed against all locations will be the topic of debate and motion practice in a contested hearing in front of the Board of Pharmacy, and ultimately appealable to an appellate officer within our office and the Supreme Court. So I think that that's going to be, we're going to have to develop the standard of when that is as this language is becoming enacted and then starting to be utilized. But I think that will be the most common area of debate. And I think there probably will be a corporate entity who is not owned separately, is owned by, let's say, Harry's Drugs, who says, yeah, this is happening, but not at this location. And Harry's Drugs will come in and say, maybe you should condition locations 1, 2, and 3, but 4, we've never had a problem, and you can't show me that we have, and you shouldn't put conditions on location 4. I think that's going to be a topic of debate, and I look forward to that conversation because I think we'll get somewhere. We'll be able to make changes in some of the problems that we're seeing.
How much of that information will be made public?
The charging document would be made public, and all resulting motions would be made public. The hearing would be public, and the outcome would be public.
But not steps 1 and 2.
The inspection, we have interpreted it to be a matter of public record. We don't post them, we don't disclose them unless asked, but the Public Records Act doesn't protect them. And then the investigation of a complaint is completely confidential until charges are found. And Senator Collmore, I had an answer for you on the retail chain question, how many of them are retail chains. We have 133 retail drug outlets, and 105 of them are chains.
Okay, thank you.
If I may tag on, how many actual corporate entities does that represent?
Well, I think Mr. Duteau might be better. I know there's 5 within the association, but there's some outside of it. So Mr.
Yeah,
Duteau,
no, I know there are 5 drugstores,
Correct.
and there are all the food things and all those other ones.
Yeah, I'd say between 7 and 10.
Yeah.
Not all of them are members of our association.
Got it. Thanks.
You're welcome.
one should be careful not to say that Walmart is part of their association, as I did say one time. So Walmart is not part of their association.
Why does this surprise us?
Lauren, you also have to be careful with your examples because there is still a Harry's Pharmacy in Berlin.
Oh,
That's the way I use Brian.
I don't know, I honestly don't know if they're still in business. It used to be part of Harry's, which was a big, sort of what you'd call a department store in a certain kind of way.
They make
Oh, I
razors.
remember
went out of
Harry's.
business, but Harry's Pharmacy basically stayed in business as an independent pharmacy for a while. I haven't been by there in a long time, so I don't know if they're still there, but you just might want
As
to
a-
keep that in mind.
as a child, we would go to Harry's as like the big
Yeah.
event of the day, of the week.
Yeah, no, me too, yeah.
I think they make razors now.
Me too. Yes.
All right. So committee, where are we on this? came into it with a different understanding and am leaving with a different understanding. But I do think that I come down on the side with OPR on this one, because I think that if they do find that something is the result of not their own manager's policy or their own staff, but has come from someplace else, even if it's a misinterpretation of that policy, that OPR ought to be able to start looking at whether this happens in more than one location without having to open a separate investigation and a separate, I guess investigation is the right word, for each one, but to do it under the corporate headquarters of OPR, and to look at, and if in the initial stages, OPR finds out that it isn't as a result of an edict from above, then they would deal individually with the pharmacies that are not performing the way they should. If they find that it is as a result of an edict from above, then they would continue and figure out which of the pharmacies are impacted as a part of that corporation and which ones should have sanctions. Do I understand that?
Summarized that far better than I did, but yes, you did.
So I just, I don't see the need to have, if the same thing is happening as a result of a policy in 5 locations owned by the same corporation, I don't see the need for OPR to open 5 different investigations for that same issue.
And that's what we're trying to avoid, right? But
That is exactly what I'm trying to avoid.
that's why I would support this.
Committee?
Yes.
Yes, I would support it also.
Grudgingly.
Senator Rahm?
Yeah, I have no questions or concerns.
Yeah, because I was thinking that there were different standards being imposed on the chains, but that isn't the case here. So my misunderstanding led me down a different path to begin with.
And I will submit the written testimony. I'm going to modify it a little bit from what I sent to the House. My written testimony on this issue with the survey is under House GovOps. I'll obviously send it to all of you later this afternoon. My morning got away from me, so I apologize.
All right. And thank you, Mr. Duteau. I think that we were swayed by our Office of Professional Regulation, and hopefully all of those issues will be dealt with in the first steps of before it gets to a charging policy, or and can be worked out and continue the conversation between the pharmacies and corporations and OPR.
Well, thank you. And again, as I stated initially, you know, we enjoy a very good relationship with OPR. It's a respectful and professional relationship. We'll continue to work very closely with them. You know, again, we still have concerns about this, but I think the best way to address concerns is continued and open dialogue. So I certainly appreciate the opportunity today, and thank you very much for your time.
Thank you. And you realize we do have an OPR bill every year.
Yes.
I want to
Thank
reciprocate
you.
the gratitude for the conversation. It's been a good conversation that I've had with Mr. Duteau, and I'm very appreciative of it because it's a hard topic, and sometimes how the conversation proceeds when the topic is hard really boils down to who's engaged in the conversation. And Mr. Duteau has been excellent to work with. So I just want to say thank you.
It's mutual. Thank you.
And may I just say, as a committee member, Mike, it's very helpful to hear an outsider's view and confirmation of the great work of our OPR office, because we don't necessarily hear from an outside user this way. So thank you. That's it. It's interesting to hear.
Well, you're
Okay.
welcome. It's well deserved.
Thank you.
Thank you.
Okay. So I see we still have David Englander with us. And did you want to speak with us about death certificates?
I would love to speak with you about death certificates if you'll have me briefly.
We would love to have you.
Excellent. So my name is David Englander. I'm the Senior Policy and Legal Advisor for the Commissioner of Health. My testimony today, so we're talking about death certificates and who's eligible to sign them. And I just wanted to clear up some misconceptions that were shared with the committee the other day on this issue. So number one is that the Department of Health has not changed any policy or practice with regard to who is eligible. There was no shift in decision making. We've maintained throughout that Vermont law is actually very clear with regard to death certificates. I'm going to read briefly from 4999. 2, a licensed healthcare professional means a physician, physician assistant, or advanced practice nurse. Director Hibbert mentioned this the other day. It's very, very clear in Vermont law that a naturopathic doctor has to be hold themselves out as a naturopathic doctor, an ND, a naturopathic physician. And so when it says physician, we presume the legislature was being precise in its language, and when it says an ND is something else, that those are two distinct categories. So that has been our position, not that the law would have to be changed to accommodate them, but rather the law is very clear. We presume that the General Assembly made a specific policy decision that we're carrying out. In addition, just so you know, a search of the death certificates on the database did not reveal any death certificates signed by naturopaths. So I just wanted to put that out there as a matter of clarity. I can stop there.
I do have some questions.
Please.
So we often write laws knowing what we know at the time. And so Mike, I have two questions. When was this statute put in place? Was it before we even licensed NDs in the state? Or so we didn't have NDs at the time, so there was no reason to accommodate them. And then regardless of what the law says, what is the harm, I guess, in having an ND sign? Because we can change the law, that's what we do. Mm-hmm. But is there a harm produced by allowing an ND to? I understand that the law is very clear.
Yeah.
But my question is, why would we maintain that law? When was it put into place, and what is the harm in changing it?
So it's a great question. So obviously in two different questions. Mm-hmm. So I don't, and perhaps Director Hibbert knows the answer. I don't know when NDs became a licensed professional in the state.
I think around 2006, around there.
So
Go try and find the answer.
When?
I'm sorry.
I will investigate. I will be back with that answer.
It was after I got into the legislature and while I was still on health and welfare. So.
Wow, that's pretty late to have been licensing doctors.
NDs.
Oh, N. Sorry, I'm sorry. Yes, it's hard. M and N.
Yeah. No, the reason I said when was we clearly said physicians at the time, meaning medical doctors,
Right.
because that's what we had. My question was, we wouldn't have put NDs in there because we didn't have them at the time the law was crafted, is my guess. But anyway.
Although we assume, as somebody who interprets laws, since I'm not allowed to write them, we assume that the legislature has all that in mind. So when they instituted the ND, the naturopathic, when they established that as a licensed professional, that they would go through that was an intentional choice, that profession was not added to the death certificate.
I don't think it was. I can tell you then I was involved with the legislation at the time, and we did not go through all of the statutes to find out where it said physician.
No, and I'm simply speaking to a matter of interpretation that we wouldn't, at the Department of Health, we wouldn't make a value judgment.
Right, right.
We would simply look at the law and say, are they eligible, yes or no?
Right. So what is the harm?
Madam Chair, if I can just put in, it looks like naturopaths were, regulation of them started in 1995, and then their section of the statute was touched in 2001, in 1997, 2001, 2002, 2005, 2007, 2009, and 2009.
Wow.
So multiple modifications of the chapter. I'm just looking at one section of the law, but it does look like the regulation of them started in 1995.
Oh, okay. All right. Thank you.
And actually, I'm happy to dig into this. I actually think that this language was added the language from death certificates in the vital records chapter. I think that was added after that.
Okay. Well, so
but I'll find out for sure.
But let's figure out now, what is the harm?
Yes.
Why would could we change this without doing harm to the public?
Sure. So in speaking with the office of the chief medical examiner and a few other doctors, I'm not going to give you a clear, I don't have a clear answer, because I think all of us, or most of us, are at deficit to understand the naturopathic physician's training with regard to the processes of death. What I understand from talking to the office of the chief medical examiner is that even MDs with training, there is a significant complexity in determining death, and that the chief medical examiner frequently does trainings for physicians, for APRNs and for PAs, in order to assist them in determining the cause of death. That it is extremely complex. The office of chief medical examiner goes through every death certificate that comes through the office, 5,000 death certificates a year. And the office examines every single one to make determinations as to the precision of the finding, and spends many of their days in between autopsies contacting the licensed professionals and walking through their thinking and how they came to determination. So I think, put simply, I think it is sensible to put the burden on NDs to make a demonstration to the committee that they have the sufficient training and experience to make these determinations.
Mm-hmm. Yeah, I think that we've asked them to do that. And can I just ask you a question here? Is Beverly Hillstrom our chief ME?
No, it's Dr. Steve Shapiro.
Oh, apparently you don't read Archer Mayer and Joe Gunther.
Oh, I'm so sorry.
Sorry.
I don't really read fiction.
Well, you should.
No, I know. It's one of the many ways in which I'm a failure as a human being.
No, it's just an opportunity, David. It's an opportunity. I'm going to write that down.
Senator Collmore.
Thank you, Madam Chair. I guess I'll ask the question that's kind of 180 degrees from your question, Madam Chair. What's the problem we're trying to solve? Is it just because there's a group of people who would like to be able to do this, or do we have enough doctors to assign death certificates? I don't understand what the issue is that we're trying to solve.
Oh, I can tell you what the issue is. I believe is if my primary care person is a naturopath, and that's who I'm seeing, And I know plenty of people who only see naturopaths and I die. Shouldn't that my primary care person be able to sign my death certificate? Instead of having to go find another doctor who doesn't even know me to sign the death certificate. That's the problem. It isn't that we don't have enough doctors to sign it. It's who's taking care of me and do they have the training to be able to determine my cause of death for me and my family.
All right.
That's, yeah.
The law,
That's
as far as I'm able to understand it from Mr. Englander, says you got to call a doctor, an MD. That's the way it is.
Yeah.
But if your primary doctor is your ND naturopath, it doesn't make any sense to call it an MD. They've made a choice to not have an MD. They've made a choice to have a naturopath.
But when they made that choice, it was also obvious that they wouldn't be able to sign death certificates.
I don't think it was obvious. I think that if I'm a patient, I wouldn't have any reason to know that if I die, my doc can't sign I consider, yes, Senator Rahm.
How many other states let naturopaths sign death certificates?
Maybe Lauren knows. We asked.
I don't know. I haven't looked into that since the last hearing. I could try to find that out, but I thought that the Association for Naturopaths was going to bring that information.
I think Josh was going to get back to us with that.
Yes, and I think that Mr. Englander is right, that what we need to do is the responsibility here is on the naturopaths to show that they do have the training to be able to determine cause of death. And if that's true, then then we can change the law. If that's not true, then we probably leave the law the way it is right now. But if they do have the training to determine cause of death, or close enough that if the chief medical examiner goes through all the death certificates anyway, and even questions some that are signed by MDs, then and maybe they have to have that as part of their ongoing professional development training, is whatever training the chief medical examiner gives around determining cause of death. I don't know, but I think you're right. We need to ask them to show us that they have the training.
Yep.
I just want to, I don't know if David or anyone else has a thought related to this, but I tend to have the same line of inquiry that Senator Collmore does. And maybe it's because I sat across from Vince Aluzzi on a lot of conference committees about burials and death, where he wanted to just have cremation without the chief medical officer pronouncing someone dead. And so, have a lot of experience thinking about this, but, it just seems that signing a death certificate is not just about the individual and their family. In fact, that's just a small part of what a death certificate means in society. So, I just feel like we're focusing a lot on what the person's wishes would be, but a death certificate has a lot to do with Department of Health records, trends, patterns, foul play, crime, etc. So I just don't hear us having enough of that conversation.
So,
I do agree with you, but I think that if they've had as much training as a medical doctor, then they should have the right to do it. And I will disclose here that I was the administrative director of an integrated holistic health clinic. And we employed naturopaths, and we had 23 different modalities. And those naturopaths were, in my opinion, as well versed in determining infectious diseases and cause of death. And so they would not, having them sign it would not disrupt the research that needs to be done by the Department of Health. But that's just my personal opinion. But we do need to have them weigh in.
Asked Josh to bring this information back. So I think we should wait and have this conversation when we get the
Yep.
Is Josh head of like the naturopaths society? Is he like empowered by the other naturopaths to speak for the naturopaths? Okay.
And we can also, if you have naturopaths that you know, and have any, if you have constituents who are naturopaths, it would be great for them to weigh in. I mean,
Well, I think that the important thing is here if they've been trained or not.
Right.
Just if they haven't been trained, it doesn't make any difference if all 55 of them come in and say, yes, I ought to be able to do this, if they haven't been trained.
Right.
If they have been trained, then even if 30 of them come in and say, I never want to sign a death certificate, that shouldn't sway us either. It should be whether they have the training and are capable of determining the cause of death.
Right. I found his testimony very informal and not sort of like, I've surveyed all my members and here's what's happening. So that concerned me. And I really, when we talk about what other states are doing, et cetera, I'd rather rely on someone else for information. That's all I'm saying. If a constituent is listening to me right now, wants to reach out, great. But I found it too informal to be reliable.
Well, that's, we'll see what he brings in when he comes with the training.
And I think we sometimes have to be careful not to just to separate the message from the messenger.
Yeah. Lauren.
Senator Rahm, I will look into the issue before next Tuesday, and I'll do my best to find the answer. I don't have the same network that he has in terms of other associations, but I can do some research on my own, and I'll try to find the answer, and perhaps David could talk to other departments of health as well.
And maybe the chief medical examiner, if he is it a he or a she?
Shapiro.
Is the he, Stephen Shapiro.
He has information about what kind of training he feels would be necessary to have to determine it. Then we can weigh that against what training there is.
I'm sorry.
No, and he may have experience with naturopaths and be okay with, think this is a good idea.
Well, he wouldn't, because he said there have been none signed by naturopaths.
Oh, he's already weighed in. I hadn't.
No, yes. Oh, yes.
But
David testified to that.
Oh, that was got it.
So it would be incredibly useful for the OCME to be able to look at the training. If the NDs can provide a curriculum, it'd be incredibly useful for us to be able to look at it and examine it and then provide testimony on the substance of it.
Yep, and that's what we will do. So we will not do anything with this bill at all until we get that information and we get the fee information for the MMAs. And then we have the APRN request to do a cataloging of all the places where physician is used. I know that Betsy Ann Rask started that project a number of years ago. I have no idea what happened to it. But I guess I'll check with Ameren, maybe if you want to check with Ledge Council and just see where that went, because I know she had started it at the time to look at different places where it might say physician, where it really should say physician and medical physician, ND, or APRN.
Yes, I can look at that.
Okay, thanks. Are there other issues around the OPR bill that we need to resolve? So it's just really the death certificates, the potential cataloging, and the MMA fees. Senator Clarkson?
If the general contractors bill, if the contractors bill gets over H157, I think it is, would we consider consolidating it and putting it onto the OPR bill? And would OPR want us to do that? I'm just curious. given it's an OPR registration. Remember, it's this light touch, our favorite subject. I'm just curious. I mean,
So I think there's two questions there. The first one, I think, is entirely up to your committee. And the second one, I believe, Senator Clarkson, you were addressing to me. So the Office of Professional Regulation strongly supports the home contractor bill. I don't think, even though we're not in the building, I'm sure that you all have felt the ripple effects of it going through the House. So, or have heard rumor of how it's gone through the House. So I would almost prefer that it stay its own bill and stand on its own merits than drag. I don't think that it should drag down the OPR bill. I think it's a good bill. It's a consumer protection bill. It is a light touch bill. If this committee gets that bill, you'll hear me testify about my support of this bill. And if you don't, and you want to talk to me about it anytime, I'm happy to talk about it. The office supports H157. That being said, it has been a very interesting legislative path heretofore. I'm excited. I'm excited for where it goes next, but I wouldn't want it to affect the other issues that I'm also advocating for.
Okay.
And that's the best way that I can surmise my position.
I agree with you, because I think that bill itself is going to be much more controversial than anything in the OPR bill.
Yeah, and they've done good work in the House, and they've gotten it through. Third reading happened yesterday, so it's coming our way, and it's probably coming to this committee. And at the Senate Economic Development will probably ask to weigh in on the licensure and contract pieces. But other than that, my guess is it's coming here.
I look forward to talking about it with you all.
Good. And I look forward to having it on the floor again.
I don't look forward to it.
I listen, that was one of that. I reported that bill. I took it. I managed to get it through. We got it to the House. Where they're finally dealing with it now. And now it's back to us.
I think it passed.
It did pass.
It did pass.
Yep, they passed third reading yesterday.
Yeah.
Yeah, we had Chip Troiano, who represented, who was the reporter Chip came into Senate Economic Development this morning.
Oh. Okay, well, I just feel sorry for the poor college kid who's going to have to spend $250 on a registration fee because he puts new steps on my back porch.
Honey, so it no longer is it that reasonable. The house
$3,500.
Yeah, they've gone. It's way over. Yes, but we can have the opportunity to make it better.
Did you say 3,500?
Yes.
Yes. If you do anything over $3,500, you have to have a written contract and you have to have your $250 registration.
No, it's now $3,500. It's $3,500 to register, and it's $3,500 threshold.
No,
it's $75 for an individual and $250 for a business, and $3,500 as the threshold to register.
So we misunderstood that this morning. This morning, I thought that there was another $3,500 that they made it tit for tat. Okay, great. That's good. That's great. It keeps, because the registration fee is not that much. It's just the job, and they've raised that, Jeanette, to $3,500. So you'll be happy with that.
No, $3,500. Have you tried to do any carpentry lately?
Yes, I know but it also, as we know, is one of the top consumer protection issues in the state. More people.
Okay, we've gotten a little bit off topic here. We'll deal with that if it comes to us.
It's a preamble.
I look forward to the conversation.
I'm sure we all do.
Hey, it could be worse.
Okay, well, thank you. I think that we have, let's see, I have so many Oh, do we have Becky coming in on H330? Thank you, David, for joining us, and thank you, Lauren.
Did you want to hear from me on MA,
Do
MMA
you have the
fees?
fees?
Yes.
Oh, you have. Oh, okay. I didn't
Yes.
know that you had settled on them.
Yes,
Okay.
we did.
Sure.
And I did send some proposed language to Amarin. I don't know if that's made it onto the website, Amarin. Okay, let me find it. Essentially, the fees would be the same. The piece that is changing is the gate tax from the event. And the rationale for changing it is we have very small venues in Vermont. And so to take 5% of the gross receipts from an event might dissuade people from coming in and holding events because the seat numbers are smaller than, say, New Jersey. So I'm just not picking on New Jersey, but New Jersey has big venues and we have small ones. So the language is in the new section, and I think that is draft 1.5. Is that, I'm sorry, Amarin, is that correct? Is it draft 1.5?
It is draft 1.5. It's on page 17 in section 6039.
That's our amendment, right?
Yes.
Yes. So the new language starts to contemplate the idea of net receipts. So what will happen is we will take then a percentage of the net receipts, a 5% percentage, 5% of the net receipts. So we'll take the gross, which is receipts from tickets, admissions, fees, and sponsorships after all the costs from the event and any other state or federal taxes thereon have been paid. And we did talk about that with Mr. Thompson, and he is thinks this is a good solution, and so does OPR.
Oh, great. Any questions about that? That sounds like a good solution. Thank you.
Oh, you're welcome. I can't actually take very much credit for it. Lauren Lehman and Rex Thompson did that. So.
Okay. Well, we're lucky to have two Laurens.
Yes.
Okay, any other questions for Lauren?
The other piece that Amarin and I have been talking about is the effective dates of this bill. I think I mentioned on Tuesday that I do need the well drillers to be effective on passage, and there's a couple of sections that mention well drillers. The other piece is the uniform endorsement.
I'm sorry. Before we leave the tax section and the fee section, I have a question. I apologize, Lauren. I just was reading this, and the promoter pays the tax to the tax department. There's a tax on every feed, every piece. Why would they pay it to the Department of Professional Regulation?
I think it's a great question. It's why I don't love the word tax. It's an event fee. It's not a tax like one would pay to the tax department. But we did use the word tax because that is the word that's used in other states. And it's to support the regulatory program to do the inspections, to manage any unprofessional conduct complaints.
I get that, and I think that's great. But there is a tax. We tax every event, so there is a Vermont state tax on every ticket sold to a theater, to a film, to
That's
a
right.
MA. So I hate to be a stickler here, but the tax is paid to the tax department. Whatever they pay to you needs to be called something else, or should be called something else, in my humble opinion.
I think that they use that because other states use it and because it's used in the boxing statutes that currently exist in Vermont.
How do we differentiate the sales tax, which is on every ticket?
Because it's a net receipts tax.
This is a net receipts. How did I miss that?
This tax is going to be 5% of the, essentially of the profit. 5% of the, what's left after expenses are paid. So it's 5% of the
Okay,
net.
so this is after they've paid the trust tax of the
Everything.
Right,
I
everything.
apologize. I guess
And the way that OPR will operationalize this is we'll create a form for the promoter to fill out and calculate what the gross receipts were, how much they paid to the state, how much they had to pay for the physician who had to attend the fight, how much they had to pay the fighters, all the costs of the fight, the location, and then that will dramatically reduce the total that we're calculating the 5% on. And that was the accommodation that we made with Mr. Thompson.
Senator Rahm, you had a question?
Yeah, I mean, just while we have Lauren, and this has been raised in this committee, but it may show up in H-159, which is in Senate Economic Development. That bill has a whole section on supporting BIPOC businesses and entrepreneurs. So it sort of calls for the creation of more of that system for identifying demographic information for business registration. And I personally feel like that's a good place to put in OPR as well, because for a lot of businesses, they're a sole proprietor, they're just a licensed person. And I think it's time we start respectfully collecting that demographic information. So that'll probably show up in Senate Economic Development as a discussion.
I look forward to the conversation, Senator Rahm. I heard you not last time I came before this committee, but maybe the time before on that topic. I've thought a lot about it. I've thought about how we could operationalize it. I would want to make sure that it was, and I can talk about this in Senate Development or wherever it's appropriate, but I want to make sure that we collect the data as the legislature recommends, but that it's not tied to a specific licensure decision. Maybe it could be something done post licensure decision or separate from the application. I just want to be very careful that I don't introduce any opportunity outside of what already exists in what we all know to just be in the world of bias on the behalf of my team. And I don't think that my team would do that, but I just want to be careful. And I want to talk to some other licensing agencies to see how they handle this issue, because I want to be very conscious of what we do with the data and how we use it, and what the expectations are from the legislature and from the Secretary of State on what we do with the data, who we release it to, how we analyze it. All of those questions are big for me, because I don't want to collect the data and then do nothing with it, or create the impression for anyone that I am doing something with it, which I think is the other piece that I just want to be careful of. So I look forward to the conversation. I think there's some really exciting opportunities there. Whether it's in this committee or in Senate Development, I look forward to it.
It is an interesting question about how you collect that, because I know with public housing, for example, when you fill out an application for public housing, it asks you for race and ethnicity, but it very clearly says this is optional because of the fear of discrimination against if you fill it out. So it's interesting how you collect it without there being a perception that you're using it in a negative manner. So
and some articulation of why
right.
is the other piece to the person. You know, if someone is asking me my race and my sexual orientation and my marriage status, I want to know why they're asking me those things, because those things matter to me personally when I disclose it. And I have been treated differently on the basis of my answers to those questions. So I don't want to willy-nilly give that information to everybody. So, but I'm very fortunate in that my, the way that makes me different is not noticeable by my name.
as not noticeable by where I went to college. You know, if I went to a historically Black college, for instance, one could make an assumption about who I was, or if I had a more, a name that wasn't Lauren, that would be, you know, someone could make an assumption about who my race was. So those are just questions that for me personally, I think about, but also I would take a lot of responsibility in gathering the data. So I just want to make sure that I'm doing it in an appropriate way and in a respectful way.
And we need to make sure that in every department and every agency, if we could collect that information, that this is a little bit off that topic, but we were having a conversation the other night and something came up about ethnic food. And my friend said, well, what is ethnic food anyway? If you live in Saudi Arabia, is mashed potatoes an ethnic food? I mean, what do we consider an ethnic food here? Because lutefisk and lefse, are they ethnic foods?
Yes. And you know, that's the joke, is that ethnic food here is not ethnic food where it was originally created. And yet anything that has a tie to some ethnicity is considered ethnic food, which is ridiculous. It's all American food.
I've never heard of lutefisk and lefse considered ethnic food. Most people just consider it not food.
Well, there's that.
Well, I think there's a lot of important conversations to be had about whiteness being the definition of standard and everything else being outside of that. And
right, exactly.
I think it's a really important conversation. And I feel the same way with male being standard and heteronormativity being standard. I think it's really important conversation. So I look forward to the conversation. And all the intricacies that are involved. And also operationally, I did ask my team how they would do it. I think there's some opportunities with SurveyMonkey or our software system to do the collection of that data in a voluntary way or in an involuntary way, depending on the direction of the legislature.
So can I just ask on this conversation before we switch here, you mentioned H-159. I'm not sure what that is, but is there a role for the state to somehow come up with a standard way of collecting data and how it's going to be used and stuff, so that it doesn't depend on each agency and each department? Is that
a question for me?
Well, for anybody. I just am throwing that out because I think it's we have many agencies and many departments, and we're looking at how do you collect data and why do you collect it, and is there a standard way and a standard way of using it and releasing it and aggregating it? And
it's a good question for Sue Zeller, and it does raise the question that Keisha's asked, which is, we don't have a planning department, would sort of belong in planning or in HR or in Sue Zeller's. I mean, you know, we don't have an office of the Vermont citizen, which would go, that's a good question, is where does it belong? And it or maybe it belongs with Tanya as part of our archive of who we are.
That's an interesting question. We should have that conversation.
It would be great to have one place to go get it. I mean, where do you go now when you want to see the Castleton poll, all the data that's collected about Vermonters? And it's, once we have a reliable source, it would be great to funnel it all there so we could go one place to get it, for just like we go to JFO to get a fiscal note on something. We could go somewhere to get a demographic note or a.
Yeah, I just was wondering, because we have a bill in judiciary right now that's setting up a whole bureau to just collect racial data in the criminal justice system. And I'm thinking, why would we separate
we
collecting it there from
all on every
Anyway.
I do think there's the potential to be very siloed, which goes to my question about what do I do with the demographic information once I collect it, and what are people expecting my office to do with it, which is probably even more important. It certainly could be a topic of part of the annual report that we file every year. but what further responsibilities would we have? And I feel fairly confident that I would do what was expected, but I would want it to be put into the statute so that the next director would do that as well, and so that it was clear what the legislature was intending.
Speaking of putting it into the statutes, so the next time we do OPR, we will look at the death certificate question and the potential language from the CSG.
Oh, great.
Okay,
Thank you so much for your time.
thank you.
It's always a pleasure.
And I see Becky is here with us. Thank you, Amran. Hi, Becky. So you were going to give us some information about the contracting procedure for with LexisNexis about our state publications and kind of what the process is and when the next time comes up.
Sure. Yeah, I didn't know exactly the information you needed, but I'm happy to generally tell you the process and answer any questions. So Becky Wasserman, Legislative Counsel. So we have, Leg Counsel is responsible for the contracting with Lexis. We do have a contract in place that the most recent one, the underlying contract was signed in November 2016, and we had some extensions to that to just renew it for a couple of years. And so as of now, the latest extension brings us to December 31st of this year. So that is when the contract is up. So under the contract right now, we don't have any more extensions available. They're usually done in 1-year extensions, and there's a certain number that you can do until you typically do another contract, although we could also just amend the contract to say we could do more. But that is, I guess that's the state of where we are in terms of when the contract is up for renegotiation. And typically we try to do that a little bit ahead of time, like, you know, a month or two ahead of time, so we're not kind of running up on the deadline.
And the contracts, remind me, good for how many years you just said? It's good.
So the underlying contract was, just double check here. It was signed in November of 2016. And I think it was I believe it was a 2-year contract, but I'm just double checking that. And then we had 2 1-year extensions on top of that.
So are you the chief negotiator with the contract on behalf of Leg Counsel?
Typically I do negotiate all of the contracts for Leg Counsel. For the Lexis ones, there are other attorneys involved just because it because it's dealing with the statutory revision process, which Jen Carby is the person that leads that. So she's also been involved, and I believe in the past Michael Chernick was more involved in the contract negotiation process as well. But I do review all of the contracts.
So I guess the question is, you saw the amendment that Tucker put onto there. Is that a reasonable amendment?
In terms of requiring that the contract and the statute line up. Yeah, I think that it would be helpful to make sure that whatever amendments are made to statute allow for it to be flexible to what the contract allows.
And that does it.
Yeah, so I think one of the issues would be is if you amend the statute to allow for something that is not in the underlying contract, then we would have an issue with how to deal with that.
Mhm.
And the statute, as you know, is not easy to change. So, and the contract is something that does get renegotiated fairly periodically. So I think that there should be some consistency to what is authorized under statute. I guess I would say I don't think it's necessary that the statute is very prescriptive over you know, the numbers of copies, or as long as it's authorizing that it can be what that it can be distributed to different parties. That, you know, the contract goes into much more detail about the
Mhm.
numbers of copies provided and the price per copy and those sorts of things. And I think that's probably more appropriate for the contract than it is for statute.
And I think that this statute does that, right? The way he's written it, it says that what he added there to the House version was that they could dispose of other publications within the terms of the contract.
Yeah, that was my understanding of the change that was made, just to keep it consistent.
Yeah.
And that being said, I think that might change practice, but it would be lining up the statute and the contract.
Which is probably a good thing.
Yeah.
That would be a good thing. Yes.
So Becky, forgive me if I totally missed this, because I apologize. I was a little preoccupied when you began. But the 1-year extensions, are we ready to sign a new contract that's a little longer than a 1-year extension every year?
Yeah, so the 1-year extension is up December 31st of 2021. So at that point, we would need to sign a new contract.
And we would hope it wouldn't just be an extension, but a contract that was for several years, so you don't have to keep duplicating your effort. It's a lot of work to do those.
Yeah, I think typically, you know, what's in them is pretty similar, but you know, it just has to, sometimes there's minor amendments that are made when we renew it. So, but I think it's typical that we have contracts that have, you know, 1-year renewals, just so that we don't have to do it every single year.
Yeah, I mean, it's a pain to have to do every year.
Yeah.
Okay, are there any other questions about that? And
Madam Chair?
Yes.
I just wanted to note that I invited Tom McMurrow at the last minute, so he is coming in a little bit late to the conversation, but I appreciate him taking the time.
Thank you. So what we've heard, Tom, is that there will be a new contract negotiated, or this contract ends December 31st. And so before then, there will be a new contract negotiated. And that the language that Tucker suggested adding around disposing of other state publications, the language that he added within the terms of the contract line up then the statutes in the contract. And so that I think what we're doing is deciding whether we should do that or not, leave that language in. And Becky has suggested that we do.
And I just found the amendment. So it says that the sale would have to be permitted by the publishing contract.
Yeah,
Right. So if I may.
Yep. And
Thank
we
you.
need to be very careful here that we're not talking about the contract itself.
Right. I just want to be clear that this applies to the Vermont statutes annotated only.
Becky?
You're muted, Becky.
The amendment language
The amendment language would apply to any, right. So yeah, this does hit the contract idea, but as the contracts currently stand, the only conflict would be with the contract with LexisNexis for printing of the Vermont statutes annotated and not any of the other publications that are mentioned.
So if it wasn't, if there's only restrictions in the contract around that, that's the only thing it would apply to. But if there were, I would think that if in the contract there, the new negotiated contract, there's some other restrictions, then that would apply to that also. Is that?
So I, not having drafted this bill, but I'm just looking at the section that it's amending, which in the underlying bill is 22 VSA 611, and that is specifically talking about the Vermont statutes annotated. So it's
Okay.
It's specifically talking about the librarian distributing copies of the VSA and then and any cumulative pocket part supplements, and that is the subject of what the publishing contract is about. So this would, I think this seems to line up with what we're talking about here of just making sure that the sale of those lines up with the publishing contract. So I guess I don't know if there's any other, what else you're looking to sell, but this this section is specifically talking about the VSA.
Tom?
Yeah, so effectively the sale of these is barred by the contract.
I don't know if it is or not.
So I think what I'm comfortable talking about is just that what the amendment is doing is allowing for whatever is in the contract to be the same as what is permitted under statute.
So if the contract would bar the sale of it, then it would be barred. If this contract says you can sell them for $2 a piece, that's what you can do. If the contract is silent on it, then I mean.
Right, and obviously we are, it's something that is negotiated, you know, every few years. So I mean, I don't know that it's always going to be the same. What's in the contract is always going to be the same. So I think this is just an attempt to make sure that what is authorized under statute is the same as what is authorized in the contract.
Any other questions about that or concerns?
Well, I have a concern. This is the state librarian. Hello, sorry for being late.
Yeah.
My 10th Zoom meeting, right, Tom? So, so I'm still alive. I think one of my concerns, I think one of my concerns for our department is, one, we don't ever have a connection to the contract. And I would love to see that grow over time, because we are what I would say are known as downstream processing. Upstream does not always know what is happening downstream. And the reason why this has a huge impact is because I will probably have to discuss this with our agency secretary, with the commissioner, Jennifer Fitch of BGS. Here's why. We are charged for transportation of those items back out to state government after they come to our department for distribution. There is a charge that comes to us, and that would come out of our budget. And if there is no incoming, not saying this provided any funding near enough to do that, I will have to discuss how the department will maintain finances of distributing these every time they come in, because we are the distribution center and BGS is a transportation that does so.
I would recommend that you be part of, you or BGS or somebody downstream, be part of the negotiating process.
Hear, hear.
And maybe
I'm happy to coordinate with that. I guess I will say that the contract does contemplate that sort of shipping distribution rate. So we can discuss that further, but I do think that is a really good point, that the parties that are involved should all know what is permitted.
Well, and the parties involved should have input, I think.
Yeah. So we will trust that you will do that, but I think that what we will do is we as a committee will write one of our famous letters to and I guess we would address it to Jen and Becky and what's is it Jennifer Fitch? Yeah.
She's the commissioner, the new commissioner of BGS.
Right. To just make sure that all the parties are involved in the, because we don't need to put that in statute.
But is she the one currently negotiating? I thought Becky was negotiating the contract.
Yeah, as I said, that we will send a copy to her so that she can see that we're asking that either she or Jason or somebody be involved in the negotiations. Yeah.
Great. Great. I think that's terrific.
Yeah. Okay. So are we ready to vote on this bill? Anybody?
Do we want to vote on it before we have answers to some of the, I guess we won't have because the contract negotiation isn't until December.
We won't have answers to anything because, and we're not really concerned about the contract. What we're concerned about is that the statute and the contract.
Very budget.
Well, we can't control that.
I know, but we can advocate, which we're doing.
We can advocate that they be involved in it. And I think Becky has said that there is some language around shipping costs and stuff. So I think that we can't go any deeper into the contract. We have no business doing that. What we have business doing is making sure that the rest of the bill passes and that we say any sale of those has to be within the terms of the contract. I said that different. Becky said it much better because she actually read the amendment. Am I right about that?
I think so. I think you are. Becky's smiling. So
that's my understanding of the amendment.
Yeah.
I think the intent behind it was just to make sure that whatever is authorized under statute is in line with what is permitted under the contract.
Yep.
And seeing as the contract is a somewhat moving target, it's better to make it a little more flexible so that we don't come up against a situation where they are perhaps in conflict.
Mm-hmm. Okay. Anybody care to move this bill?
I'd be glad to, Madam Chair, but I don't know what the number is and it's not on our agenda.
It's 337.
I'm sorry?
337, H337.
Yeah, 337. It's on today's agenda. It's 337.
I would move that the committee vote out H337 with no amendments.
No. We first need to amend it with, and I don't have in front of me the number, but I would guess it's 1.1. That was the only amendment.
We should have it here.
Yeah, Tucker did send it to us.
Under Tucker's name, and it's, oh no, I'm wrong.
Allison, if you want to make the motion, I still don't see it on the agenda.
Oh, it's on the agenda under today.
Really?
At least I was seeing it on the agenda under today.
Yeah, it is. Was set for 3 o'clock.
3 o'clock, it says H337, but what I don't see in our documents is I don't see Tucker's.
Well, it wouldn't be in our documents for today. It was some time ago.
Oh,
I think it might have been
It was March 31st.
31st. March 31st.
I will post that
at 12 o'clock.
I will post that for today. It will just take a couple of minutes to come up.
And it is
1.1.
1.1. That's what I thought. So Brian, Senator Collmore, do you still want to make that?
Yes, Madam Chair, I'm writing it down. I move that the committee vote out the amendment containing draft 1.1 on Bill H337.
Good, thank you.
Okay, I'll call the roll. Senator Clarkson,
Yes.
Senator Collmore,
Yes.
Senator Polina,
Yes.
myself, Senator Rom, yes. Senator White,
Yes.
and the committee has amended H337 with draft 1.1 by a vote of 500.
Yes.
Now
Senator Collmore.
I further move that the committee vote out H337 as amended.
Okay.
Okay. Senator Clarkson,
Yes.
Senator Collmore,
Yes.
Senator Polina,
Yes.
myself, Senator Rom, yes. Senator White,
Yes.
and the committee passes the bill 500.
Would anybody like to report this bill? Anybody have an interest in publications in the libraries and our
We all-
publications?
We
Huh?
all have interest in libraries and publications.
But would anybody like to report the bill? I'm not seeing anybody jump around up and down about it.
Well, if I hadn't just agreed to do 151 yesterday, I guess I'm happy to do this one as well, but I mean, I'm happy if somebody else wants to do it too.
I'm happy to do it if no one else wants to, so.
Okay, well, why don't you do it? We'll be doing things close to each other.
Okay.
I'll do 151 and you're doing 337.
Okay.
What?
So,
Unless, are you thinking down the line, are you wanting to do OPR?
no, I don't, I'm perfectly happy to let anybody do any bills. I think that if we get to the point of doing the Agency of Public Safety, I probably will do that.
Yeah.
But if we get to that point, but I'm perfectly happy to let anybody report any bill they want to.
Thank you for that, Madam Chair.
So, okay. So this should be on the agenda, Jason and Tom. It should be on the agenda for,
It'll be on notice tomorrow, if you get it up there.
if we get it up there, it could be on notice tomorrow. It could be either Tuesday or Wednesday then that we do it.
I'll be on Tuesday, I think, because I think 151 will be on tomorrow.
Thank you.
The department thanks you. The state
Well,
library thanks you, and my staff thanks you.
Thank you.
Thank you.
Okay, committee.
And thank you, gentlemen, for joining us at the last minute.
Happy
Yes,
to.
and thank Becky for coming in and talking with us. So I believe at 3:30, we had scheduled some time for people to come to talk to us about our nominees. No one has contacted me. I don't know if anybody has contacted any of the rest of you
No,
or Gail.
No.
No. So what I would suggest is that we take a break,
good.
that we come back, and then we could ourselves then, knowing that if no one shows up, that we can take a vote on the 4 nominees and then forward them to the floor.
Sounds good.
Sounds good. How many minutes? 10 minutes? Till
Let's
3.
see. Yeah, let's do 15 minutes.
About 3:45.
3:40.
Or 3:40. How about 3:40?
Yeah, 3-4. Let's do, so we can have time to talk about, because there are 4 people and I'd like to get them just done with.